I'm now delighted to be joined by Erich Spangenberg, most famous for IPNav. But Erich, first, thank you very much for joining us. And secondly, is IPwe the same or different?
Thank you, Nigel. Good afternoon. IPNav was the right entity for the time. It was a licensing and enforcement advisor, and IPwe is offering a completely different solution based upon blockchain, artificial intelligence, and predictive analytics. And these solutions will facilitate the development of the patent asset class. IPNav leveraged arbitrage opportunities that existed in the patent space for a bunch of historical reasons, and IPwe is working to promote transparency and facilitate traditional as well as new types of transactions. And ultimately, if IPwe is successful, the arbitrage opportunities, access to intermediaries, and other current market attributes that suppress patent asset class will be reduced or eliminated.
So a lot of that agenda seems to hinge on transparency, but I know from my own work around Aropo that transparency to some people is not obvious. What do you think is the cause of the resistance, and how do you think IPwe will be able to overcome it?
The short answer to your question is a bunch of historical reasons that I don't think make sense anymore. The longer answer is that the current asset managers of patents are typically trained as lawyers and are trained in a system that simply does not encourage transparency or new methods of utilizing, developing, and realizing returns on patent assets. It's steeped in tradition, and while there's certainly examples, I mean, look, your Aropo example is one of them, where people try to bust out of the bowl. When you do, you encounter incredible resistance, not the least of which it's perceived as risky by many in the IP space to try new ways of doing business, and the rewards for them trying them are too abstract. I'm sure you've had these conversations with people as well, particularly, for example, in tech transfer at universities, but also at IP groups and large companies. It's actually safer for them to do nothing than to do something new, because their KPI or whatever metrics they're judged by don't necessarily reward them for doing new things, so the rewards aren't just there. So we believe that one of the most basic problems is that you'll never develop an asset class if the market is uncertain who the owner is. It requires time and money and costly intermediaries to establish ownership. Development will simply be restrained, and it's not going to happen. So think of it this way: if you weren't sure who owned equity, or you weren't sure who owned the multiple, you weren't sure, what the transactions just wouldn't happen. I don't think it's quite that bad in the patent space, but depending on who you believe, 30 to 40% error rate, and for sure expensive to determine, even putting the error rates aside. So one of the things that we're offering up and is available today is something we call the IP registry. It's ready to go, and so using traditional motivation, we think that the incentive has to be there and has to be demonstrated to patent owners, and they'll participate if you give them incentive and fundamentally fix the problem. And from the IPwe registry, we can offer them more sophisticated transactional offerings, but it all starts with that basic premise of ease in establishing ownership. I think, Nigel, probably as you know better than most, given your work with Aropo, it sounds really simple and appealing to solve the ownership transparency issues. It's not. It will require a slight modification to historical behavior and substantial resources in the form of technical development and capital to provide incentives, but we ultimately think it's worth it to make that investment.
So obviously that reference to the registry, and I've certainly read your early publicity, makes multiple references to a blockchain. How will this help move the dial, or is it just part of a bigger picture?
We think that the jumping off point to an improved asset class is transparency and ownership. As a result of conversations with a number of academics, fund managers in the space who've helped create asset classes that I suspect most people don't even know exist, they had a few fundamental themes that they talked to us about, but theme one was ease in determining ownership or the asset class just doesn't develop.
And just to finish that off, a blockchain being irrefutable closes that gap, but doesn't it have enormous costs associated with a blockchain?
It does. I just came from one of the larger blockchain conferences in the U.S., and you see some really interesting deployments of blockchain, and you see some deployments of blockchain that simply don't require blockchain. But one of the things these companies quickly find out after they get through the idea phase is actually how expensive it is to store, for example, on the Ethereum network. So the way our IPwe registry will work is it'll only work currently. Over time, we do believe that public blockchain storage costs will decline. But for the next couple of years, we're combining both a public and a private blockchain solution, simply because that cost is prohibitive to put everything up on the Ethereum or public blockchain side.
And of course, your comments about transparency seem to reach further than just ownership. Proper transparency also goes to transactions, about which you know a great deal, and licensing value, what we sometimes refer to in Europe as comparables. How do you intend to tackle the layers of confidentiality associated with these bulks of data?
Yeah, so fundamentally, there's two ways to do it, right? So you saw a few years ago the USPTO come out with proposed regulations, and a couple of people had legislation to require disclosure of licensing transactions, or I think the more likely scenario is simply behavioral modification. I just don't see legislation or the type of regulation happening in the near term, particularly where there's some draconian penalty associated with it, such as, you lose your patent or your patent's unenforceable. It didn't get traction for a bunch of reasons, and for what I view as a bunch of appropriate reasons. But in fact, there is a fair amount of data out there right now on the license. Let's just focus in on licensing. On the licensing side, it's in disparate databases, it's behind firewalls, or otherwise simply hard to get. So we're doing our best, and it costs money, to source as much of this data as we can. Getting back to the storage side, it requires both technical, and to get the information requires financial resources. But ultimately, we're going to work with the people who have this information, as well as patent owners, to convince them that it's actually in their interest to disclose this information. And if we can demonstrate that transactions will increase and associated development awards will increase as a result of enhanced disclosure over some period of time, and the views on my team and the people that I talk to range from 2 to 5 years as being realistic. I'm probably a little higher end of that range. We think ultimately the behavior will change, and we're ready to invest in the education and technology and capital required to make that change. You couldn't do it. Again, you're not going to do it just by demonstrating, telling, and educating. You're going to have to provide them a financial incentive to do it. It's going to be expensive to do.
No, I get it. And the theme of today's webinar has all been about artificial and machine learning, helping the intellectual property world develop to help patents be recognized as an asset class. How does AI and machine learning help you achieve the objectives you have for IPwe?
We touched on the themes that we had when we spoke to different asset managers outside the patent asset class, and talked about what it would take to develop the asset class. Another issue over and above ownership that they all identified is when you get to patents is that they're a legally dense document, and the basic issue of figuring out what it covers is complex, and in today's world, extremely expensive. But what we call this issue is coverage. Does a patent exist? And if it does, what particular technology does it relate to? And at some level, what does it cover? So before the lawyers who are listening to this go off, we're not trying to replace you. We actually want to work with you. You have a critical role in the system, and will going forward as well. And in fact, we think that it's easier to identify patents ownership and identify broad coverage that transaction volumes will increase from the current 2% level to something significantly higher. That's going to be good news for traditional intermediaries that change their model a bit to adapt to this new reality. But what we've seen since 2006 is that you no longer have to just start out sort of doing broad Boolean searches to figure out, but you can use much more sophisticated IPwe and machine learning techniques to address these coverage issues.
Look, this is absolutely fascinating, Eric, and for everyone who knows your background, you quite like to succeed, and that success is obviously associated oftentimes with financial objectives. To the extent that it's not too early to say, what's the financial model for IPwe benefiting from the increased liquidity of the asset class?
So think about blockchain, and there's all kinds of articles out there on what it means to ultimately go peer-to-peer, and I think some people are tad optimistic that intermediaries will just be completely eliminated. But I think what will happen is that you're going to see intermediary costs come down dramatically. So in today's market, if you look at the academic research, somewhere between 30 and 40% and even higher transaction costs estimated. Liquidity discounts approaching 90%. So when you see that in the asset class, that was just pure fortuity for me that I saw that, read about blockchain, and said, hey, these two might fit together. So with the trillions or so spent on R&D, or billions spent on patent regulation, 200 billion on licensing and acquisition transactions per year per WIPO, we think that by addressing these fundamental issues that we touched on today, that we can expand the number of transactions from 2% on transactions, 5% on what gets commercially developed, and ultimately what we'll do across our platform is capture a very small piece, measured in basis points of those transactions, and that's our business model going forward. So again, we're not in the SaaS model. We're not into SaaS models. We're not looking to sell Zeus Analytics for a monthly subscription. We're giving a version of it away. There's a higher end version. If you want to pay for it, feel free. But the base model is that the tools you need to transact are there and available for free. If and when you decide to transact, then you'll pay, but measured in, again, basis points, not percentages. And ultimately, in order to be successful, we need to see that 2 and 5% go up, some multiple of that, maybe 3-4 times. And so will society and patent owners and regulators, and we're all going to benefit from it.
Look, Eric, thank you very much for joining us this afternoon. I'm sure I'm not alone in saying that we'll be watching the IPwe story very closely, and from a transparency perspective, clearly there are many people who will be incredibly supportive of your work. Thank you.